One of the big questions I've been receiving is, what are the chances of me getting detained at my USCIS asylum interview? And I don't actually know the answer to that, but what I will tell you is that I focus on family-based immigration, but I also handle deportation defense cases, which I'm trying to admittedly do less and less of because I enjoy family-based immigration more. But oftentimes, I need to discuss the consequences of a denied application with clients. And they ask me what defenses from deportation that they might have available to them. And one of the defenses that I sometimes mention is asylum. And oftentimes, recently, clients will say to me, oh, no. I definitely don't want to apply for asylum. That's how you end up getting deported or arrested or detained when you show up to USCIS or court, or ICE just comes to your house and detains you. And I need to kind of correct them a little bit because that's not entirely true. So I just want to talk a little bit about that in today's video. There have been a lot of changes to the way that asylum cases are being processed. Some things that a lot of people hear about is that asylum seekers who show up to their hearings in immigration court are getting detained. And that is true. That is happening. Specifically, it's happening mostly in New York, where the Trump administration is running a pilot program where they ask judges to dismiss cases. It's happening in other cities as well, but like the vast majority of the cases are in New York City at 26 Federal Plaza. So the Department of Homeland Security will ask the judges to dismiss the cases. The judge will grant the motion to dismiss, and then when the respondent, the immigrant, leaves that courtroom, ICE immediately apprehends them, detains them, and begins to effectuate something known as expedited removal, which is only available if you're no longer in removal proceedings. So it's a little bit of a dirty trick that the Trump administration is using to curtail people's right to apply for asylum in the United States. But there's a big difference between applying for asylum defensively when you're in removal proceedings versus somebody who's not in removal proceedings, has no active immigration court case pending, and, for example, entered the US on a visa or entered without inspection but had no contact with immigration officials. Someone who is not in removal proceedings can apply for asylum affirmatively with USCIS. So there are two ways to apply for asylum. One would be defensively, as a defense from deportation. These are people who have already received a notice to appear and are in removal proceedings. The second way is to affirmatively apply for asylum directly with a USCIS asylum office. I'm going to be mostly talking about affirmative asylum applications here. Asylum is usually restricted to people who apply within their first year of entering the United States. There are exceptions. For example, if you entered the US on parole or you had some sort of other provisional status and that status expires or is about to expire, you could still apply for asylum under one of the exceptional circumstances exceptions, which basically allows you to show that you had lawful immigration status. Upon that status terminating, you applied for asylum within a reasonable time. That doesn't mean you get a full year after your status, like TPS or parole or whatever. It could even be your tourist visa entry. You don't get a full year after that expires, but you have to apply within a reasonable time. And the adjudicator, which is going to be the USCIS officer, or down the road, if you get denied, the immigration judge, is the one who's going to determine whether you applied within a reasonable time. If you apply for asylum affirmatively with the USCIS office and they deny your case, they're going to now refer your case to immigration court, where you have a second opportunity to apply for asylum in front of an immigration judge. And when you do not apply for asylum within the first year of entering and you want to make some sort of exceptional circumstances argument, usually USCIS will, as a matter of policy, deny that application and refer it to the judge so that a judge can make a determination on whether you applied within the appropriate time, whether you qualify for one of the exceptions, to see if you're actually eligible for asylum. One of the big questions I've been receiving is, what are the chances of me getting detained at my USCIS asylum interview? And I don't actually know the answer to that, but what I will tell you is that I see people attend asylum interviews at the USCIS offices, the field offices, all the time. And I personally have never seen anyone detained at these interviews. Now, I'm sure it's possible, especially if you have criminal history or some sort of old removal order that they didn't catch initially and then you show up for the interview. It's possible that ICE officers will be there ready to apprehend and detain you and to begin removing you from the United States. That's possible. I just haven't been seeing it. Like, I've attended a couple asylum interviews and they're busier than ever, and I don't see ICE officers there. That doesn't mean it's impossible. I just don't think that the risk of getting detained at an affirmative asylum interview is that high for the average asylum seeker. There are a couple changes that I want to mention in this video that have taken place since the Trump administration took office for the second time. The main change is that asylum applications are being reviewed very quickly now. If you submit an asylum application, Form I-589, it's possible that your interview will be in less than 180 days. And that's a magic line in the sand for employment authorization. So once you have an asylum application pending for longer than 180 days, you are eligible to apply for an employment authorization document, also known as a work permit. However, if USCIS makes a final determination on your asylum application within those 180 days, the clock will stop until the case gets transferred to immigration court, and then once your case is pending in immigration court, the clock will restart, and then you can now work towards getting those 180 days so that you could apply for your work permit. But now you're already in removal proceedings, and depending on the jurisdiction you're in, your removal proceedings might proceed pretty quickly. The problem is that now you're applying for your work permit and you're already actively in removal proceedings. So something that a lot of people used to do was apply for asylum, get their work permit, and then wait like 10 years before a final decision is made on their asylum application. During those 10 years, other options might become available. They might marry a US citizen and then be able to cancel their asylum process and just get a green card through their US citizen spouse. They might qualify for other benefits like temporary protected status, which would offer an alternative option in the event that their asylum application is ultimately denied. But realistically, like, a lot of people would just come here, submit an asylum application, get temporary employment authorization that they just keep renewing for a decade. I've even seen people do this for like 2 decades continuously before a final decision is made on their asylum application. The last time Trump became president, towards the second half of his administration, he sped up the asylum interviews to deter people from applying solely for employment authorization. And I speculated as soon as he won the election that that policy was going to come back in full force. And it has. So now people who apply for asylum should expect that their initial interview will be within 6 months. It might not always be the case where it's within 6 months, but that's certainly what I've seen in New York and the surrounding states. One final thing that I want to mention. A lot of people are panicking because of all of the increased immigration enforcement, and they will submit an asylum application when they are not eligible for asylum. I see this happen all the time with people who submit their application with a document preparer, also sometimes referred to as notarios. You see these shops in major cities where they say, like, we do immigration, we do your taxes, we do like tax ID numbers, we help you with government applications. From what I've seen, these are non-attorneys actually practicing law in a lot of instances by applying the client's facts to the law. That is what the practice of law actually is. And I see these people ruin people's lives inadvertently all the time. They think they're helping people sometimes by giving them like a good deal and doing what a lawyer does and preparing an asylum application and helping people get work permits. And at first, all is great when you get your work permit in the mail. But 10 years later, when you actually need to defend that asylum application and you easily get a removal order because you never qualified for asylum to begin with, that's when the house of cards begins falling down. So I will just say one final thing. If you are considering applying for asylum, make sure that you use an attorney, because the statistics of people who prepare their own asylum application versus people who use an attorney are dramatic. Like something like 5% of people who don't use an attorney get their cases approved, whereas if you use an attorney, depending on geography, your odds could be higher than 50%. You know, depends on a lot of variables. You need to actually be eligible, but dramatic differences in outcomes with people who use an attorney versus don't use an attorney. And one thing that I do recommend doing is verify that the person you're using is actually an attorney. In New York State, you can just Google New York State attorney lookup and it'll bring you to the New York Courts attorney registration page where you can just type any attorney's name in and it'll tell you their full name, when they got licensed, any instances of misconduct that were alleged against them, and whether they are currently in good standing. So I always recommend doing that before you hire any attorney. You could always call their office, ask them like, what's your legal name? I want to just look up to make sure you have an active license. And it's a good preventative measure to take before you submit an application, the outcome of which could impact the direction of your life and your family's future. So if you want to see if I can handle your case, schedule a consultation. My information is in the video description below. You just click the link, schedule a consultation, and I would be more than happy to speak with you to see how I can best assist you and your family. And finally, if you're new to my channel, be sure to subscribe. I put out several videos each week on recent changes to family-based immigration, naturalization, and deportation defense. So if you want to get a unique perspective on these topics from an immigration attorney, be sure to subscribe, and I'll see you guys next time for another video.